When government officials are sued, qualified immunity functions as an affirmative defense they can raise, barring money damages even if they committed unlawful acts. Which brings us to a discussion regarding the test for qualified immunity. Under Harlow and his progeny, two questions need to be asked. First, did the officer's conduct violate a constitutional right? And if so, was that right clearly established? Under this test, an officer could be found to have violated a constitutional right, but if the law was not clearly established at the time of the incident, the officer may be entitled to qualified immunity and not be liable for money damages. So how does a court determine whether the law is clearly established at the time the officer allegedly violated the plaintiff's rights? Generally speaking, courts require plaintiffs to point to an already existing judicial opinion with substantially similar facts, putting officers on notice that the conduct at issue was already deemed unlawful. Can it be any court decision that puts the officer on notice? Well, in the 2018 case entitled District of Columbia versus Westby, the United States Supreme Court acknowledged that it has not yet decided what precedents other than its own would qualify as controlling authority for purposes of qualified immunity. On the other hand, several circuit courts look to the United States Supreme Court in cases from their own circuits, as well as to cases from other courts exhibiting what is considered to be a consensus view. Now, up until 2009, the two-part test was required to be examined in this order. However, that changed with the Supreme Court decision in the Pearson case. Now, courts can skip directly to the second question without ever having to decide the merits of whether an officer violated a constitutional right. And some argue that this has resulted in fewer precedents finding a constitutional violation, thus putting officers on notice as to what conduct is deemed constitutional and what conduct is not deemed constitutional. All right, we want to talk about.
If I can just jump in on that quick before we get to this next. Yes. I'll just speak to myself. You can go to the next slide. That's okay. But I just for myself, as you know, I've been training for 30 years, and I like to have answers. I like to know what is allowable, what's not allowable. So from that perspective, I find the Pearson case in the second prong being answered sometimes without the first one being answered can be frustrating, because I wait for something, it goes to SCOTUS or it goes to, and then they, well, you know, we decline to take on that issue because all we need to hold is that it's not clearly established. So that leaves us kind of in the void. So there are some legitimate, you know, at least I feel anyway, from my perspective, concerns about that.